Now, the upmarket food and clothing outlet Woolworths has been accused of unfair labour practice. This after it has been embroiled in a cultural storm after the retail giant allegedly suspended an employee for wearing Isiphandla, a traditional animal skin wristband. Now, Woolworths has since indicated that the employee was not suspended for wearing it. She was suspended for unrelated disciplinary matters. And this matter raises a number of questions on the Section 6 of the Employment Equity Act, which prohibits the unfair targeting of employees on a range of issues, including cultural and religious beliefs. Just last month, the South African National Defence Force withdrew charges against a Muslim major, Fatima Isaacs, who refused to remove her headscarf. A little bit earlier on, Palliser spoke to the Chief Director, Labour Relations at the Department of Labour, Thembinkosi, Mkhaliphi.
The law is clear. I mean, an employee can be dismissed and be suspended. The issue is that dismissal and suspension fair. And now let's look at this case. And also the law talks to company policy. What is a company policy on different issues? And is that company policy on itself fair? Now, you might have a case that says, well, if you work in a company that produces food, that cook food, you might have an issue that says, well, there's a company policy that says, if you bring a skin that might contain the food that they are producing, the company policy might indicate that. And they might be able to argue fairness on that and win the case. Now, if you work in a construction company, in the mine, there's no issues about food on there and all of those issues, you might be able to argue that it's irrelevant here. I mean, the issue of cultural weapons, for example. I mean, we carry sticks, we carry all sorts of cultural weapons. People believing that it's their culture to carry this. Can you bring it in the workplace? Can an employer say, well, our policy is that you can't bring such weapons, even if your culture says so, you can't bring such instrument into the workplace.
So are you saying that there are instances where the policies of companies can sort of overrule what the provision of the law is?
No, it's not overruling. Remember,
because the moment if a company tells me that, listen, you're not allowed to have your Isiphandla because you work with food can be contaminated, it certainly means that now the policies are sort of superior to the rule of law.
Remember what I've said.
Yeah.
I've said in terms of the law, the issue that the law would look at, anybody looking at the case, is that reasonable? Would a reasonable person be doing that? Is that fair for the company to do that? Because the other issue is, if I go to a company that sells food and I buy food and it comes out that the food that I bought were contaminated and then I get sick. Look at the issue with Tiger brand, the that affected people, killed people. Now, if a company knowingly that what you're wearing is going to affect its customers and allow you to do that, and then it spoiled the food, and then it's going to have to answer that. Therefore, it's not about whether it trims the law. The issue is it a fair restriction on your right? The law gives you a right. Is then
the issue of fairness has to come into play.
If the company's policy make a fair restriction, because they restrict your right in terms of the law. The law says you cannot be discriminated against your religious belief, your all other issues, cultural belief. Yeah. That's what the law says.
But listen, in some instances, perhaps I would join the company before everything happens, and along the way, certain cultural practices have to be performed. Of course, one can say that, listen, you've joined the company knowing that there are certain things that you're not allowed to do, but obviously you can't predict the future. At a particular time along the way, you have to undergo certain practices and certain rituals, for example. What must happen in such instances? Because they can always take you back to the contract and say, this is what your contract says.
Again, fairness will come into this picture. In determining fairness, anybody deciding the case in determining fairness will say, is this rule, this policy known by all the workers? If it's known, then the issue, should you have known about it? If the policy is there, is put in the cabinet, nobody knows about it, is the policy being applied consistently? Are they allowing somebody else to do something that has got the same effect, but they do not allow you? All of those things, they come into the picture when you need to decide whether the decision taken by the company on the basis of its policy is a fair decision or not.
So what's the best way to handle the situation as an employee and an employer?
Well, for an employer, the best way of handling it, if you've got a policy, whatever policy it is, make sure that your employees know about the policy and that policy is implemented consistently. As an employer, as an employee, if you're coming to be employed in the company, make sure that you know what is it that you're allowed to do and what is it that you're not allowed to do. So that when you do anything, be it cultural, be it any other thing that you do in the company, you know the policy. If you know the policy and you do it at your own risk, then that's a decision that you take. But the issue, you still can challenge that if you believe that the policy is unfair.
But then you have, on this Woolworths case, some legal experts saying that this amounts to unfair labor practice, saying that the store would even go as far as losing this case if they were to go to CCMA.
Nobody can make that assumption without knowing all the facts. As I've said, the CCMA will have to look at the facts, look at the policy. Why is the company saying you cannot wear Isiphandla? And look and interrogate those facts. If the company put on facts that shows that if you wear this, this is a danger that they're trying to avoid, the CCMA will have to listen to that. Therefore, nobody can sit here and tell you that this is an unfair labor practice, they can lose it or win it. Don't know whether they'll win it or lose it.
Because again, the employee, from what we're reading, had apparently made the management aware that she was going to undergo certain ritual practices and she was going to have to wear Isiphandla for a certain period of time. So what happens in the case where I go to my employer and let them know that this is what I'm going through and this is not going to take forever, but I would need time to complete the rituals?
Well, there are options in this issue. If the policy is clear that if you do your rituals and your rituals are a threat to the business, let's say they say, well, this is affect our business in terms of we are in the food business. The opportunity is there to say, okay, we'll remove you and put you in the clothing business, not in the food business, because and then you can do your ritual. The other opportunity is if it's just a food business, there's no clothing business, there's nowhere they can put you, they could say, okay, take your leave for that period and wear your Isiphandla. Or they could say, take
But the thing
unpaid
about
leave.
Isiphandla, for example, you have to wait for it to fall off itself. There is no a specific period to wear it.
Yes, understand that.
Yeah.
The issues, I mean, it's the same issue with people that are going for circumcision in the mountain. And they say to the employer, we need to do this. Does that mean that the employer must give them 3 months holiday? And the employer will say, well, if you want to do it, this is your cultural responsibility, you need, take your leave, take the days that you have, do this. All of this within reason, there's got to be a discussion between the two parties. The most important issue, the employer must not act unfairly. At the same time, the employer must protect their customers because they cannot put their customers also at risk if there's any, I'm not saying that wearing Isiphandla does introduce a risk. If that's the argument and they can prove it, then they've got an obligation to their customers also.
All right. So what happens in an instance where there are no customers or clients to be affected? Let's take, for instance, the issue of Major Fatima Isaacs from the SANDF, who had taken this matter up because she was not allowed to wear a headscarf, as it is the policy of the South African National Defence Force. In that regard,
Well,
what happens?
Maybe that's why this defense force withdrew the case. Because how are they going to be? How are they going to argue that the wearing of the scarf affect the business? And how are they going to argue that it is a fair decision that they are taking? That because now they are interfering with the right, restricting the rights of the employee. They've got to be able to convince the judge, they've got to be able to convince the CCMA, if it goes to the CCMA, that the restriction on this employee's right is fair and reasonable. If they cannot do that, and the only way of showing that is fair and reasonable, they've got to show the effect it will have on their business as the defense force. Now, if they can't show that,
it's a problem.
It's a problem.
Yeah. But how often do you come across such cases? How often do employees go to the Department of Labor with such cases?
Remember, employees, no, we don't get this because they don't have to come to the Department of Labor. It's all about dismissal. It's all about fairness and not fairness. And maybe these kind of cases go to the CCMA, and the CCMA will have some stats in terms of how many cases they've said. But